Hi guys, this is Rajiv S. Khanna for immigration.com, the law offices of Rajiv S. Khanna PC. On November 7th, we could not do a live conference call, so I'm recording the answers for you folks as promised on Tuesday, November 12th, 2013. I was called away. We have a client who had some emergency. So that said, let me just get into the questions. The first one is from Miriam Monk, who wants to become a US citizen, but they pleaded guilty to a crime 6 years ago. The question is, how does that impact US citizenship? Normally, USCIS can go back in time as much as they want, but they normally look at the last 5 years. Okay? So, in 5 years, if you have not committed any crimes or been in any problems, chances are you might be able to get your citizenship. It's worth trying. Please get a lawyer involved. I would suggest that you work with a lawyer locally where you are and try to file your application for citizenship. It might go through. The next question is from Ficaret about a 212A4 denial, which is a public charge ground denial. Basically, it means the embassy or the consulate was not convinced that your son will not become a burden on the US government because you cannot support them. Okay, so the questions that you have asked me are highly fact bound. It is very difficult for me to give you a generic answer. A good answer that I can give you is that many times the 212A4 denials can be overcome through different methods. And by the way, you can also get a co-sponsor, and it does not have to be a member of the family. It can be a friend. Anybody who is a US green card holder or US citizen can become a co-sponsor. So let the consulate know that you send them an email that you're in the process of providing more information, and please don't close my case. You can also send the same material, a request through the local congressman's office. They should be able to tell you what kind of information will help you overcome the 212A4 problem. What is the procedure to recapture H1B time out of the country? Basically, you provide information about how many times you were outside the United States, how many days you were outside the US, and as a part of the normal H1 filing, they will give you the time that you were outside USA. There is no question about that. But you've got to establish that you were indeed outside for that time. Okay, now you're asking me things like what is the fees, what is the LCA? Please get yourself a lawyer. You should not tinker with H1 visas yourself. This is something that only lawyers should help you do. Okay. Um, ECE wants to know about the application of CSPA to their daughter's case. Now, it's very difficult for me to give a definitive opinion, but it looks like she has aged out and there's nothing you can do. Why? Because it appears that she was the I-130 was pending for only 2 months, and she can only take out 2 months from 21 years and 4 months, which means she's still over 21. So it does not look like the CSPA would help. Um, I'm not sure what the exact details of your daughter's case are, but from what you are describing, it appears to me that it's not going to help. Okay. Next question is from TVU about the Tri-Valley University case. They have entered since the Tri-Valley University denial on B1, B2 once. Second time when they tried to enter on B1, B2, they were allowed to withdraw the application, which is very good. So the question is, when I'm interviewed in my home country for my green card through my wife, how should I prepare and what should I do about information relating to TVU? The answer is nothing special needs to be done. You just need to be honest about whatever happened. If they ask you, they may not even ask you these questions. And if they do ask you, just be honest about it. Um, the next question is from rr.nels, H1 and EAD at the same time, which one to choose? The facts are a little bit unclear. She got her H1 while in the United States. Um, then she got an EAD. Now, what is not clear to me is, where did the EAD come from? Was it based upon your husband's I-485 filing? I'm assuming that the the EAD that you got was based upon your husband's I-485 filing. If the EAD was given by mistake or in error, of course you cannot use it. But if it was based upon a valid, good I-485 filing of your husband, which is what I'm assuming here, um, now can I search a job with my EAD? The answer is yes. If you have an EAD which is proper and valid, um, an I-485 based EAD, it's almost like a green card. You can get a job anywhere. You can get more than one job. You can even start your own business. Or you can choose not to work, or you can be in between jobs in between. So it's not, that EAD is very flexible. Then you have a question about breaking a contract. That's a question of contract law. You need to talk with a local lawyer. On immigration.com, we have an article on something called liquidated damages. Um, I'm going to try to get to that article. So if you go to the page called About Us, okay, and if you look at the articles, here it says Rajiv's articles, you go to that page, you'll come away with with this liquidated damages clauses in H1B visa. It's a publication that is directly relevant to your questions. You should have that reviewed, that publication reviewed by your contract lawyers, whoever are reviewing your contract, and only they can answer this question. I cannot answer this question because it's a contract law question, not immigration law question. Contract law is a matter of state. Each state has its own contract law. Will my H1 get invalid if I start working using my EAD? The answer is yes. If you start using your EAD, your H1 kind of goes to sleep. In order for you to wake it back up, you have to go outside USA and re-enter using H1 visa. Then you are back on H1, working at the H1 job, if you re-enter on H1 visa. So EAD use kind of puts your H1 to sleep. Here the question is, if somebody's wife filed a dowry harassment case in India, would that affect naturalization in USA? And the answer is it depends. If the case is a criminal case, then definitely it can have a problematic effect on your naturalization application. If it's just a civil case, there is no problem. From Satish NY, there's a question about sister-in-law's test and interview for naturalization. During the interview, the interviewer asked her about all the details of her trips outside the US, and when she couldn't account for all of them, he says he's going to put her back in the processing queue. Is this legal? Well, yes, and it's definitely, the officer can pretty much ask anything related to the naturalization. But if she doesn't remember, that should not be a ground to really fail them. I would certainly advise you to contact your local congressman's office and ask for them to have this looked into, because it sounds very unreasonable for them to deny an application or delay an application on the basis that an applicant cannot offhand recite the entire detail of their absences when it's already been given in the naturalization application. So do that, and I don't think she should be asked to take the test again. I think this matter should be resolved without too many issues. Contact your congressman's office, okay? Suresh wants to know whether having a CA, Chartered Accountancy degree, Chartered Accountancy qualification from India helps moving towards master's, let me rephrase that, towards bachelor's degree. So if you have a BCom, which is 3 years, and then you have CA, Chartered Accountancy, would that help? I've looked at your details, and the problem is the Administrative Appeals Office has flip-flopped on this issue. For cost accountancy, if I remember correctly, they actually relented a little bit because um, there was a ruling from um, the, what are they called? I think Indian Grants Commission, which said that, okay, now we consider cost accountancy, or was it corporate secretary, a company secretary, one of those two diplomas, they had started considering them equivalent to a bachelor's degree. Um, so AAO has said that they will accept that. Well, let me rephrase that. So they have had a very shaky position on that. Earlier, they used to say this can never be accepted as equivalent to a US bachelor's degree. CA, they have done a lot of cases where they've said they will not accept. Okay. But what I'm saying is somebody should sit down and go over the latest rulings from AAO and see if there is anything in your favor. If not, I'm afraid you're going to be stuck with EP3 and there isn't much you can do about it. They have flip-flopped. One of the very problematic rulings from AAO said, even if University Grants Commission, UGC, that's right, University Grants Commission accepts this as equivalent to a bachelor's degree, a 4-year bachelor's degree, because the chartered accountancy organization or company's secretary's organization are not a university or a school, they don't accept them as degrees in the United States under USCIS rulings. Okay, so it has to be studied. I cannot give you an answer without looking at the most recent rulings on this issue. I think it's unlikely, but it's certainly worth looking into. A, a Pandey 18 got a notification for supervised recruitment during the perm case. Um, So the question is, what should I do? First of all, supervised recruitment cannot be avoided. I'm surprised that your lawyers have not told you that. Once an employer gets supervised recruitment, they cannot just back away from it. It's a very bad idea. And I disagree that the supervised recruitments have only a 10 to 20% success rate. Absolutely incorrect. Absolutely and completely incorrect. Supervised recruitment is just like another kind of recruitment. Only thing is that the resumes, instead of going directly to the employer, go first to the Department of Labor. So, I am surprised that your lawyers are even considering walking away from it. They should not walk away from it. Okay. So, should you continue with another employer? Look, all of those options are open to you. It doesn't hurt if you walk away from this, but it can hurt the employer. So I'm not even sure why your lawyers are considering the option of walking away. Okay, I think it should be dealt with. Mystique wants to know if I have a J1 HRR waiver pending and I get married to a US citizen, and the reason for the waiver request was I want to obtain a master's degree. Can that waiver, if obtained, be used to get married and get a green card? And the answer is sure. Once the waiver is given, no matter what the reasons are, if your reasons changed, like in your case, your boyfriend proposed and you want to get married, if you get a waiver, that same reason is good for anything. I don't see how that would be a problem. At least to the best of my knowledge, it's not an issue. SAC has an interesting situation. They were working for employer A who filed their green card, and then they used AC-21 from employer B, hoping to join them, but they never joined them. They continued to work for employer A. Green card has just gotten approved. So the question is, now employer A is paying $15,000 less than what the AC-21 salary was, or prevailing wage was. Is this a problem? And that's a very difficult question to answer. There really is no law covering these issues. Okay. If you can, it would be great if you can go and join employer B. That appears to be the cleanest option. But if you continued working for employer A, will you have trouble during naturalization? It is impossible for me to predict what will happen. This is not a situation that's covered by any law. Okay, but if you can join employer B, that would definitely be the cleanest situation. NEWW wants to know, how do I deal with a uh, juvenile conviction for shoplifting? As far as I know, you have to reveal it, okay? Um, and that should not become a problem. I don't think that should stop you from getting your naturalization. But another thing you can do is, if you are unsure about this and you do not want to reveal it, you should definitely have your congressman look into it. So you contact your congressman, you tell them, I have a question about a past conviction. Can you please find out what I have to do with this? They should be able to get you the answer. In my view, it has to be revealed, and also in my view, it should not be a problem. George has a situation where she's got about 10 months left on her H1, and the employer has not filed for um, a green card, so there is no way to extend this H1. Her husband, should he get on to H4 or should he go on to F1 because he wants to apply for H1B in the next cycle? And the answer is, in your situation, F1 seems to be a better option if he does get successful changeover to F1, because that way you can go on to F2. And of course, changing back to H1 for him or for you is no problem if you and he indeed get the F1, F2 that you've requested. That is the key component. F1, F2 can be denied because there are several considerations that USCIS looks at when granting F1, such as the intention to return back to your home country. They choose to make an issue of it, they can. And they can deny your F1 or F2 application on those bases. Parashkam has a situation. They've completed their 6 years on H1. They went back, got an H4 visa and came back, and then the employer who had applied for their perm application applied for I-140 and got it approved last week. So the question is, can I work for another employer if I get my H1? The answer is yes, you can. Even though you are currently on H4 and you are not working, you can get a 3-year H1 extension through any employer. Do they need to start green card process all over again? Yes. What will happen to my priority date with company A? That remains your property. So even if you start a green card all over again with another employer, you will maintain the same priority date as it was with the employer A. Katraj has an issue where he thinks that, Satish actually is the name. Satish thinks that the new employer has not ported the old employer's priority date of 2009. Have I lost it? And the answer is no. Once your I-140 is approved through any employer, there's nothing really that you have to do. That priority date is automatically your property. All you can do is make sure USCIS is aware of it if they are not. They are usually, believe me, because what they do is they do periodic checks several times a week or month, where they look at what the priority dates are and what is the earliest priority date available to you, and they are supposed to automatically assign that to you. Okay, just in case it has skipped their attention, it can be brought to their attention through a call to the customer service, as well as a letter, making them aware that even though your new priority date is 2013, it should be 2009 and EB2 category. No problem at all. You will not lose it. There is no way you can lose it. You can only lose it if USCIS revokes the old I-140 for fraud or for misrepresentation. Even if the old employer revokes the I-140, the priority date still remains your property. Nikat's wife is in India. He's got his citizenship and he wants to apply for a K3 and I-130. That is the fastest option. You do get work authorization once she gets it on K3 visa. It appears to me that this is the fastest way. I cannot think of anything else, unless she can come back on an L1, which might be faster. But if she cannot come back on L1 or H1, then K3 I-130 combo is the best way to go. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.